Good morning, good evening, good afternoon. So I'm here early for a nonsense appearance. On the one hand, I enjoy getting paid to make appearances. On the other hand, it kind of sucks that the client has to pay me for a nonsense hearing. Nothing's going to happen today, but the courts demand it, and so here we are. Anyway, in the meantime, there's been a couple interesting things and a couple cases that I found interesting. The first thing is in Long Island Audits versus, I want to say, Freyes? His ill-fated defamation case in Florida. The defense, for reasons that I don't really understand, but I don't practice law in Florida, they wanted an evidentiary hearing. And Long Island Audits opposed it, but they're going to get one. So I think what they're going to be looking at is standing and maybe a few other things. An evidentiary hearing is essentially a trial. It's not the ultimate trial of the case where the ultimate facts are determined. Evidentiary hearings are generally what you call mini trials, essentially, on preliminary issues. So I don't really know what they're trying to do. It doesn't make a whole lot of sense to me that they would have an evidentiary hearing this early into the case. But I, again, don't practice law in Florida, so I'm going to trust the judgment of the Florida attorneys who are asking for it. So we'll see how that goes. You know, one of the things that's always difficult for me is there is a type of attorney out there who will do things that won't necessarily get results, or that may not be designed to get results, period, but are done to generate billing. And those kind of attorneys always annoy me because you're like, why are you doing this? What am I missing? And then it turns out that it was nonsense just designed to generate billing hours. And, you know, if I'm opposing counsel on the case, that means I've generated billing hours, which is good on that one hand, but bad that my client had to pay for nonsense. So, I mean, this whole evidentiary hearing in Long Island Audits, just the fact that Long Island Audits opposed it means that it's at least annoying to him. So I could see why defense is doing it, but I don't really understand why defense is doing that. But I guess we'll see. The next case I want to talk about is Chille's Oklahoma case, the criminal case that's been brought against him. And he's filed a motion for a Franks hearing. Now, Franks hearing is, I want to say it's like Franks versus Delaware. It's a Supreme Court case where essentially a defendant gets to challenge a finding of probable cause. Usually it's used in regards to like search warrants, and it's not usually done in regards to arrest warrants. But it can be done with any kind of probable cause determination that the state has used to execute a warrant, right? And generally what you're looking for in a Franks hearing, what the defendant's burden is to show that there is some material fact that the affiant who gave the declaration, the affidavit of probable cause to the magistrate or the judge to make a probable cause finding on, that there's a material fact that the affiant either left out or made up. It has to be material. Like if that fact is excluded from the probable cause declaration or inserted into it, as the case may be, if that wouldn't change whether or not the finder of fact could have determined that there was still probable cause, then the Franks hearing results in no change. If, however, it would have changed whether or not the judge or magistrate finds probable cause, then you can get, if it's a search warrant, you can get the evidence excluded. If it's an arrest warrant, you might get the whole thing tossed out. You know, different states have implemented that rule differently. I don't, through a casual perusal of Oklahoma state law, it does not appear that Oklahoma has a material difference in the way that they approach it from California or the federal court. So Chille's got a long road to hoe. The things that he's alleged, the alleged issues of his Franks hearing, are either things that the affiant wouldn't have or couldn't have known, like what he was saying on his live streams and things like that. Because in the affidavit for probable cause, the affiant was like watching him either through a window or via security cameras test various, I'm going to guess, undercover vehicles. They were all like silver F-150s. So if you ever see a silver F-150, if you're driving through that area of Oklahoma, assume it's a cop. But they were all like unmarked vehicles, and so he would go and he would look in. The affiant said, with his camera, he'd film the interior, which is not an element, so it's immaterial that they included that, but they included all of the information and more that they had to. And he tried several doors, including the affiant's vehicle's door. Now, he didn't have permission from the affiant or anybody else that I'm aware of to try any of the doors, the door handles on any of these vehicles. And so just because, like, the material thing is that vehicle was the affiant's, she hadn't given him permission to try the door, to manipulate the door handle, to molest the door handle, to molest a mechanism or appliance of the vehicle, which is relevant because she hadn't given him permission to try her door. Boom, there you go. There it is. And she also reasonably believes she has relevant information that he was not given permission to try any of the other vehicles' doors, because they're all cop vehicles and they all presumably have, cop paraphernalia in them, guns, computers, etc., that he shouldn't have access to. So just those things. She saw him manipulate the handle on her vehicle's door. Boom, there's probable cause. So him trying to put in things like, well, he stated on camera that he wasn't trying to commit a crime. Well, who the fuck cares, right? Nothing that you say can be used for you. Everything that you say can be used against you. And just think about how simple it would be in life if every criminal, all they had to do to get out of it was saying, I wasn't trying to commit a crime. Well, obviously that doesn't work. That's stupid. He was also saying that he was engaged in First Amendment protected activity. Well, first of all, that's a legal conclusion. It's not a fact. The affiant indicated that he was filming into these things. Like, he had a camera and he was filming, right? So you're going to say, oh, it's First Amendment protected activity. Well, maybe it is, maybe it isn't. For example, a quick point in fact, if you put a camera on your shoe and you try to film up ladies' skirts, that's probably a crime. That's probably not First Amendment protected activity, depending on state law. But I think most states, if not all states, have peeping Tom laws where that would be a crime. Oh, but I was filming. It's First Amendment protected activity. Maybe there might be signs places. Just because you have a camera and you're filming doesn't mean it's First Amendment protected activity. A court has to look at it. The court's going to look at the totality of the circumstances to determine whether or not that was in fact First Amendment protected activity. But ultimately, it's a legal conclusion. It is a legal conclusion that the court can make and that an observer can't make. Chille might 100% believe that what he was doing was First Amendment protected activity, and it may or may not be, but he doesn't know that, and I don't know that, and the court doesn't know that, and it's not relevant to anything. Again, just because you're filming while you're committing a crime doesn't make the crime not occur. If you pick someone's pocket while you're filming, is it First Amendment protected activity? Well, maybe the filming is, but picking the pocket isn't. Just imagine this. If you record yourself sexually assaulting someone, does that automatically make it, oh, it's First Amendment protected activity? No. Filming yourself or filming while you're committing a crime does not make the crime excused. He talks about I went and reported to the officer in charge, some Sergeant Woods, what I was doing and why. Well, first of all, Sergeant Woods, or Major Woods, I think it was, Major Woods wasn't the affiant. So him telling someone else who's not the affiant something doesn't mean the affiant knows. It doesn't mean the person who signs the affidavit of probable cause doesn't mean that they know. Oh, because I was showing this in the video, that means that there wasn't probable cause. Well, did the affiant know? Was the affiant watching your video? Is there anything in the affidavit that suggests that the affiant was watching your video? No, there wasn't. So, first of all, how could the affiant know? And again, probable cause just means that crime was probably being committed and you probably committed it. That's it. It doesn't mean a crime was committed. There's a difference. I know that's hard for small minds to understand, but someone can have probable cause that you committed a crime even if you hadn't committed a crime. They walk in, they see you standing over a dead body with a gun. Well, that's probable cause. That doesn't mean that you are the person who killed him. I mean, you might have just fought off the attacker and might be 100% innocent, but they still have probable cause, right? It doesn't mean you committed a crime. And this will tie into the next case I talk about. So, and then Chille wants to believe that the particular statute is designed to target people who are joyriding, and indeed, the jury instruction is a joyriding instructions. But if you look at, there's a bunch of and or statements. So if you manipulate or molest a mechanism or appliance on somebody else's vehicle without their permission, you've committed the crime. Testing door handles could meet all of the elements in the jury instructions. And funnily enough, there was a typo in the jury instructions, in the official jury instructions. They called it an automobile, not automobile, M-O-B-I-L-E. They have M-O-B-L-E, which I thought was hilarious. A typo in your jury instructions. What kind of podunk state is Oklahoma? Not trying to poop on Oklahoma, but come on. I'm like, what? A typo in the jury instruction? So anyway, I can go through the jury instruction and I can get to a jury convicting him. I mean, I could get there just going through the jury instruction. I'm not saying a jury will convict him. I'm saying that going through the jury instruction, I can get to him getting a conviction. Like, I can match all of the elements for every single, I could find evidence that fits every single element of the crime. You don't have to actually get in the vehicle. You don't actually have to try to turn it on. All you have to do is molest a mechanism or appliance of the vehicle, which would include a doorknob. That's a mechanism. A door handle is a mechanism. So I don't expect his Franks. I mean, even if the court gives him the Franks hearing, I don't expect the Franks hearing to go well for him. Yeah, I mean, I don't see it. But, good luck to him. Good luck to you, Chille. I don't want to see you in jail. I'm under the presumption that you're just going to stay out of Oklahoma until everything blows over. Probably, maybe for the rest of your life. I don't know. But I don't want to see anybody go to jail, including Chille. I mean, as much of a, turd burglar as Chille is, I don't want anybody to go to jail. I don't like it. I understand that some people need that we need to get rid of some people and put them in jail, et cetera, but I don't have to like it. And then, so finally, Chille has a federal lawsuit. It's been going on for a long time in Las Vegas, where he approached a driver who'd been pulled over in a parking lot. He started yelling and screaming. He got arrested for it, and he went to trial. He was convicted at trial, but then it was overturned on appeal. So in the civil suit against the officers who arrested him, he has pled a lot of things, and he hasn't really shown anything. Like, he doesn't have a medical expert who says this is the amount of damage, etc. He's got like $150 bill from a Doc in a Box, where he shows that he has a bruise on where his ulnar nerve would be under. And, a bruise is great. That does show that there was some physical damage, but, it doesn't really establish like the medical costs, and it doesn't really establish pain and suffering. Again, pain and suffering is generally like, if you're gonna, juries can come to different conclusions, but generally it's about 3 times your medicals. Generally, pain and suffering is about 3 times your medicals. So if you have $100 in medicals, you might expect to get about $300 in pain and suffering. You're certainly not going to get $100,000 or more in pain and suffering. Well, almost certainly not. Because most jurors, most judges kind of think that, well, if all that you had to do was get prescribed an aspirin and you spent, 50 cents on an aspirin, it probably didn't hurt that much. You probably didn't have that much pain and suffering, But if you have to go and get reconstructive surgery on your leg and you'll never walk right again, and the medical expert is going to come in and testify that you're going to be in pain and suffering for the rest of your life, you're going to have to have prescriptions for like some OxyContin or something like that to dull the pain for the rest of your life. That when the weather changes, you're going to experience shooting pain. You're never going to be able to run. You're never going to be able to chase your kids again. You're going to have special accommodations, yada yada yada. Those are the things that build up the general damages. That's evidence of like actual pain. So you can see the kind of difference between going to a doc in a box, paying $150 to have them take a picture of a bruise, and actual medical damages where you would get actual pain and suffering. So they have an omnibus motion in limine where they're going to attempt to limit certain things that Chille is going to be able to bring in. And I think the most damaging is that Chille isn't going to able to bring in any evidence of medical stuff if the judge grants the motion in limine, or bring in an expert to testify about it, because Chille never produced an expert. He never identified an expert. And so he can't bring an expert. And they're very likely going to be able to win on the no expert testimony thing. And the only person who could really testify to medical stuff is an expert. You got to have a doctor in there. In my experience, the court is only going to listen to a doctor about medical stuff. So, good luck to you, Chille, on that. That's really going to limit damages. And of course, damages are speculative because first he has to prove that there wasn't probable cause. And the fact that a prosecutor determined there was probable cause and brought it to trial, where even though it was overturned on appeal, that judge and that prosecutor thought that there was probable cause, is pretty good indication that there was in fact probable cause. So it's very likely, and they did move to exclude any reference to the criminal trial. They did move to exclude that as well. So they won't be able to say that, but the just because there was all of this, because so many reasonable people came to the reasonable conclusion that there was probable cause, which again doesn't mean he did it. It just means that, a reasonable cop would think that a crime was probably being committed and you probably committed it. It's a really low bar. It's a really low bar. So he's still got to get past that. And once he gets past that, is a bruise on his ulnar nerve, especially when the videos come in. And the videos are going to come in of him acting like an asshole. Like, it's a jury trial, and, despite what Chille in his bubble thinks, most people don't like Chille, and most people don't like the way he interacts with cops, and most people don't like the way he attempts to antagonize cops. Most people don't like it. So he's got a long road to hoe in the Las Vegas federal case, the 1983 case against the cops who arrested him. So anyway, but again, good luck to you, Chille. Good luck to you. It's not like the cops are going to pay anything. The city's going to cover the cost of it because the city's already found the cops were reasonable. That's why the city's defending him. So the city thinks the cops were reasonable in doing what they did. And yeah. But anyway, good luck to you, Chille. Anyway, that's all I got for you today. Thanks for watching. Have a great day.